Estate Planning After the 2010 Tax Act was a live webinar that was originally produced on Thursday, September 15th, 2016. The presenters for this presentation were Greg Lowe with McConley & Asbury and Stan Smith from Rhodes & Sinan. Enjoy this webinar recap and visit us online at www.macpas.com for more information about our future events and presentations.
Thanks, Tyler, and thank you, Stan, for being willing to join us today for this topic. I've known you, I think, for 25 years and also done some estate planning with you myself, so we really appreciate you being here to talk with our listeners today.
My pleasure, Greg.
I guess by way of just jumping in, if you would, why don't you give us, before we get into the meat of this, kind of a summary of what's ahead for us today and what you're going to attempt to take us through.
Thanks, Greg. The situation that we're facing right now is we had a regimen that in many ways drove estate planning for decades, and that is the federal estate tax law that, for the most part, for higher net worth individuals and business owners, becomes one of the key driving forces when people are putting their estate plans together. And what I've observed is that it's hard to teach old dogs new tricks at times, and there are a lot of individuals that implemented estate plans based on the approach of the pre-2010 Tax Act that have not been diligent to review and update those plans. And also, some people passed away with those plans in place, and so accountants and other advisors are left with dealing with plans that were implemented under a regimen that's no longer in place. And so I think it's very important for anybody that's advising individual clients and business owners to be aware of these changes and to make sure that the advice being given is reflective of what's the new regimen.
And I know looks like we'll get to our first slide. You're going to take us through a chart that a lot of our accountants that are listening right now are going to love. Go ahead.
Okay. This is the slide that has as its top pre-2010 estate plans. And to really understand what was going on, it's important to recognize that the exemption amount drove a lot of planning. And by the exemption amount, I'm referring to the amount that an individual could transfer to family members or other people other than their spouse without incurring federal estate tax. Or another way to look at it is, what was the freebie given by the government, so to speak, before they wanted to start taking part of what an individual owned. And so this slide shows that as recently as 2001, that exemption amount, surprisingly, was $675,000. So a person with $1 million estate who died was paying federal estate tax if they didn't have a spouse or charity involved. That exemption amount, as this slide shows, under the Bush Tax Act, started to go up quite significantly, so that by, for example, the year 26, the exemption was $2 million. Now, what's really important to recognize is that wills that were being written in 2000 and before, and really up until 2010, would often incorporate by formula these exemption amounts. In other words, it was not uncommon for a person in their will to say, okay, I give the exemption amount, and fancy language is used to do that, but basically the heart of it is, I give that exemption amount to a trust, and then you would spell out the terms of that trust. And so what started to happen, unbeknownst to a lot of people, is that formula amount was controlling a widely different amount than what it controlled when they wrote and signed that will. So a will written, for example, in 2003 that included that formula was bequeathing $1 million, doing nothing at all, not changing any document. In 2008, that formula was $2 million. And so the planning that was done was being inadvertently or indirectly changed by the changes in these exemption amounts.
So you're going to, I guess, take us a little bit through just an application of how this works for an individual.
Yeah, and this is really important because I find there's still a lot of wills out standing, and when I refer to wills today, I'm referring to wills and revocable trusts, whatever the keystone document is in the estate plan. It can be either a revocable trust or a will. But there are many outstanding documents that predated 2010. And what was being done at that time, and the reason this is important for advisors to understand, is that plan that sought to incorporate this changing exemption amount could no longer produce anything close to what the clients would intend. So, for example, under the pre-2010 regimen, the key concept that would be hammered home time and again was either an individual uses that exemption that you saw in the prior slide, that meaning the amount that is exempt from federal estate tax, either a person used that when they died somehow, or they lost it. So what a lot of people were told, and it was hammered home time and time again, was the old-fashioned I love you will, which was everything I have goes to my spouse, and if my spouse isn't living, it goes to the kids. That old-fashioned will for individuals that had higher net worths or owned businesses that could have significant value produced a climate where when the first spouse died, because their assets went to their spouse and not to some other beneficiary, they lost the exemption of the one who died first. That ended up with estates at the second death that were higher than needed to be, and increased the federal estate tax that was payable at the second death. So it was almost like Congress was baiting people by giving a marital deduction, but taking away the exclusion if it wasn't used in a way that normal estate plans that used a simple outright distribution at the first death to a spouse forfeited an exemption that would end up costing the family substantial taxes. So the solution that many people implemented, and that's still outstanding in a lot of documents, was what you see on this slide. The solution: create what is known as a credit shelter trust or a bypass trust or a unified credit trust or the so-called AB trust planning. It had many, many different names. But basically what clients were urged to do, and what is still in place for many people that haven't updated their plans, was an arrangement where a husband and wife would first divide up the ownership of their assets to the extent that they were able to do that. So if you think of a married couple, they might own their home.
You want to bring up Exhibit A as you kind of talk through the,
sure,
the
Greg,
solution to that?
I think that would be helpful. If you look at the screen now, you'll see an example of what was often done. So in this example, you'll see this married couple, Mike and Mary, have a home, and as is often the case, that home is titled in joint names. Mike and Mary each have retirement plans, and you can see those listed there. They had brokerage accounts, and as often the case, that was titled jointly. They each had some life insurance, and then Michael has a business interest, which you can see listed there. And so they had substantial joint assets and then also some individually owned assets. What would be the case under the pre-2010 planning would be Mike and Mary would be told, that brokerage account and bank accounts, instead of having those in joint ownership, let's put those over into Mary's name. And maybe that house, instead of that being joint, let's make that half owned by Mike and half owned by Mary as tenant in common, and so on. And what you were trying to do was build individual estates, individually titled assets, so that whoever was the first to die, and in this case, let's just say Michael was the first to die, his plan would say, okay, at my death, we will take the amount that's exempt from tax, and as you saw in that earlier slide, that was a changing amount. And so you never quite knew what it was going to be, but his will would say, okay, let's take the exemption amount, and instead of that going to my beloved wife Mary, we will distribute that to a credit shelter trust or a bypass trust, which in effect would take advantage of Mike's exemption. So, looking at that hypothetical, Mary would own her own assets, and she would end up being the beneficiary of Mike's assets that would have gone into a trust for her. That was the way couples would typically take advantage of the exemption amount when the first death occurred. And so their wills, if they haven't updated them since 2010, would in all probability incorporate a plan similar to that. The effect of all that is that may no longer be what Mike and Mary want, given the options that are provided through the new changes in the federal state tax law.
We'll bounce back to slide 8 while you're covering that.
So if you just slip over to slide 9 for a second, this is the beginning of what's changed. And very importantly, if you look at this slide, you see that in 2010 and really 2011, 2010 is an odd year because you had choices there, but basically 2011 and on, the federal estate exemption amount that each individual has is $5 million with an annual adjustment for inflation. So you can see tracking down that 2012, 2013, each year the exemption amount is rising so that the current year 2016, the federal state tax exemption or exclusion amount is $5,450,000. Now just think for a minute, if an individual wrote a will 10, 14 years ago and said, okay, take my exemption amount and put it into a trust for my spouse, and they did it when the exemption was $1 million, because of this change in the law, that will now takes $5,450,000 and puts it into a trust. And what was intended back in the year the will was signed has been radically altered by the changes in this federal state tax.
I know this next slide looks a little too easy.
Yeah, this. What are the effects of the 2010 Act? And there are really three initial main areas. The first was a slide we just looked at. What has happened is the exemption amount was radically increased to $5 million indexed to inflation, and now we're pushing at $5,450,000 each person. So before long, when you look at it from a married couple standpoint, you're up to the almost the 11 million stage. So a lot of people, and I think incorrectly, as we'll talk about in a little bit, think that any couple that has less than $11 million doesn't have to worry about federal estate tax anymore. I would suggest that may not be correct, and we can talk about why that is the case. But obviously the first very significant change is on that slide that shows the increasing exemption amount. The slide that we're looking at right now, portability of the exclusion amount, is a radical change that opens the doors to a lot of opportunities for clients. And if your clients have not explored how that changes their planning, they ought to do that, because I have found that many clients love the idea of taking advantage of portability. And basically what the concept is the prior rule of use it or lose it as it relates to the exemption amount is abolished. It is now a rule where one spouse can, under certain circumstances, effectively transfer their unused exclusion to their surviving spouse. So going back to that concept of a I love you will, which is everything I own I give to my spouse, even where an individual has a larger estate, like back to our Mike and Mary example, if Mike left his entire estate to Mary outright under the old I love you will, he would not forfeit his exemption amount necessarily, but could, if the appropriate paperwork is completed, transfer or assign or allow his widow to receive his exemption. So, under that scenario, if Mary ended up owning the entire 100% of the family assets and the proper paperwork was completed, Mary would not only own all of the family assets, but she would also have her own exemption, and she would have her deceased husband's exemption amount that wasn't used. So she would be sitting there effectively with almost an $11 million of estate tax exclusion, total assets of less than that on that Exhibit A hypothetical, and she would be in a situation where she could theoretically pass those assets down to their children without Uncle Sam taking a piece of the pie. That portability has radically altered the estate planning field. So the need, for example, to separate assets no longer exists in many cases. There are some instances where it still exists, and I can explain that a little later. But in a frequently encountered marital situation, the pressure for a married couple to start saying what's his and what's hers and separate titles can be avoided in many cases. I found that was singularly one of the most impeding circumstances in estate planning, was to get a happily married couple that develops substantial net worth to start dividing up assets out of joint ownership into individual ownership for estate tax reasons. They're looking at you like, well, we're married. Why do we want to divide these? And you try to explain, use it or lose it. You no longer have to have that discussion. You can explain to the couple, joint ownership still works. I love you wills, everything to my spouse still work in many cases. The third area that, and we'll come back to portability a little later in this talk, The third area that the 2010 Tax Act changed was it reduced the rate of taxation once an individual hits the federal state tax rate. That's now 40% across the board. There have been times where that rate was much, much higher than that, 55% when President Bush started the changes in the estate taxes, and before that it was even higher than 55%. So that's also an important change in the 2010 Tax Act. Okay, the question then that I find a lot of clients start to ask is, what role does a trust play for a married couple? So, for example, you have a couple that implemented wills in, say, 2005, and it followed the old pattern of separating out ownership and directing some assets into trust for the surviving spouse. Some clients say, well, I like that approach. It was not exclusively tax-driven. So what would lead an individual to wanting a trust to be created at their passing, even though their spouse survives? Well, probably the classic case, and the one that still to this day gets overlooked too often, is blended families or second marriages. So if a husband and wife who are married each has children, or one of them has children to a prior marriage, and they are doing estate planning, you have to be very careful about the I love you will or 100% outright to the one who survives, because you are creating a winner-takes-all environment. And most people on this call that have been around the estate planning field at all have seen the horror stories where the one spouse dies, the surviving spouse ends up leaving all the family assets to his or her own children, to the exclusion of the children of the one who died first, and that produces a result that in many families are viewed as somewhat inequitable. So that individual may very much want to create a trust if he or she is the first to die, which would allow them to make provision for their spouse, but still assure that those assets in the trust would pass to his or her own kids at the second death, and not just get diverted to the children or grandchildren of the spouse who was the second to die. So that's a classic non-tax reason why people may want to create a trust at the first death. And I still have some clients that have the language that mimic the estate tax exclusion language, and they want to keep it there, and they understand that today that's going to be $5,400,000 and some thousand dollars that would go into a trust for their spouse, and that's very consistent with their intentions. The point of that is they made a conscious decision, and I can't urge enough that everybody that listeners here are advising or talking with or meeting with ought to make certain that anybody that has wills that incorporated formulas and made references to the federal state tax continues to reflect and accomplish their goals. Other reasons why people may want a trust created if they're the first to die. One that I see often is protection. We many times work with individuals where one of the married couple would never say no to their kids. And that the other spouse is looking at it and thinking, if my spouse ends up owning the entire estate, they'll be destitute eventually because the kids will need $50,000 for this and want to buy a house and want to do this and want to do that, and before you know it, the surviving spouse's assets have been depleted, not dissipated, but just simply given to the loved ones prematurely, so that the surviving spouse is left with insufficient assets for his or her own needs. And so a trust would be a non-tax reason to provide some degree of protection for that surviving spouse. Another common issue that people would like to address through the use of a trust at the first death, again unrelated to estate taxes, but just why, would be to provide investment management. One spouse may just have no interest whatsoever in financial matters and would feel a great degree of relief if, instead of having to decide how to handle the inheritance, it was handled through them through a trust vehicle. And again, that would be a non-tax. Since we're hopefully speaking to some accountants, there are income tax considerations to this, and I recently encountered this situation, which was quite disappointing, I would say, in the end, and that was a client who had died in the right around 2000, had, through his very well-prepared estate plan, directed his exemption amount into a trust for his wife. His wife died several years ago after the new Estate Tax Act. And what's interesting is that trust that was created under the old regimen was a credit shelter trust or a bypass trust, so that it's not taxed in or included in the assets of the second spouse to die. When the second spouse died, her estate was less than $2 million, so she was way below the federal estate tax exclusion amount. In fact, even if you included his trust in her estate, she was nowhere close to the estate tax total of what was then a little over $5 million. What was disappointing was that the assets in the credit shelter trust do not get a new basis when the wife died, because they are not included in her estate by design. So there are lots of credit shelter trusts that are out there because of good planning that was done under the old regimen, and an individual died before the 2010 Tax Act. The second spouse is still living, but that trust is containing assets that will not be shielded will not benefit from the step-up in basis when the second spouse dies. So as a result, this new Tax Act, I would suggest, should change the investment objectives of the bypass trust that's out there. For many, many years, you would always devote the highest growth assets to the credit shelter trust and the lower growth assets to the estate of the surviving spouse, because the first would be exempt from tax at the second death, and the surviving spouse's estate presumably would be subject to tax. So if you're working with any clients where the surviving spouse is your client and is benefiting from a bypass trust, I would suggest to you that it's fruitful to go in and consider whether the investment mix of that bypass trust should be reversed to where you're not putting the high growth assets there, recognizing that you're not getting a new basis. So that's one of the income tax considerations that I think gets overlooked as a result of this new tax act.
We talked a lot about now post 2010, but do you see dangers to the new approach?
Yeah, I really do, and this is one that I have witnessed. I actually had a meeting with an accountant. We were meeting with a mutual client who was widowed, and the husband had passed away after 2010, and the total family estate was about $6 million, and his estate was about $2 million. So he had $2 million, and they basically had another $4 million of joint. So when the decedent's estate was administered, the view was it's only $2 million. You don't have to file a federal estate tax return unless you're over the filing limit, which was over $5 million, so no federal state tax return was filed. When I got involved several years later and working with the widow, I realized that because no federal estate tax return was filed for the husband, the widow did not receive or inherit the unused exclusion amount. So the great danger for advisors is filing a federal estate tax return for a deceased spouse is necessary and obligatory for the surviving spouse to get the benefit of the portable exclusion. Put another way, the surviving spouse will not inherit their deceased spouse's exclusion unless a federal estate tax return is properly filed for the decedent. So I have in many cases on estates that are in some instances quite small, filed a federal estate tax return, going through that exercise solely for the purpose of making sure the surviving spouse receives the unused exclusion of the deceased spouse. If I would urge that in any estate, if a federal estate tax return is not filed for a deceased spouse, that the advisors should get a waiver or some kind of document signed by the surviving spouse and the executor, if the surviving spouse is not the executor, acknowledging that they have been told that they are not inheriting their deceased spouse's exemption amount, and they will not have the benefit of a portable exclusion because they don't want to pay for the preparation of a federal estate tax return. I see a huge risk here for advisors because it's not beyond the realm of possibility by any means whatsoever that a surviving spouse who has a few $1 million, all of a sudden they've inherited unexpectedly, and now they have an estate that's over the estate tax exemption, and they didn't get their deceased spouse's exclusion. You're looking at a tax of 40% on every dollar over that exclusion amount, and it's going to be a situation in the coming years where people are going to point fingers. So I think it's a huge risk, but a great opportunity. I mean, it's a great opportunity for accountants to provide good advice to clients, to advise them that in a case of a deceased spouse, they should have an estate tax return filed so the surviving spouse gets the exemption, even if today that exemption isn't necessary because you just don't know what the future would hold. Another really important caveat here relates to generation skipping tax, and this is a complicated area, but one that I think anybody working in the estate tax area has to remain sensitive to. If you have a higher net worth client and that client has any possibility of estates that are going to put their children in high net worth situations. So, for example, I have a number of clients that, say they have $20 million estates and 2 kids. Those children, when mom and dad are gone, are going to, by definition, end up with estates that are over the exemption amount. And so in that context, it's very wise to recommend to the wealthy parents to take some of what they are going to leave to their children and either leave it to grandchildren or put it into a generation skipping trust for their children. That trust is one that simply says the child gets the benefit of those assets for life, but when the child is gone, they're not taxed in the child's estate. They would pass to the grandkids without that layer of tax. That's the so-called generation skip. The reason I have the beware here is it's easy to forget that this portability of exclusion does not apply to a generation skipping exclusion. So any higher net worth clients that you work with, and for this purpose I would say anybody with $7 or $8 million and above ought to be careful about giving up on the traditional approach of keeping separate assets, because if that couple wants to do generation skipping, they can't rely on portability like they can for estate tax. They are going to have some assets in separate ownership and create a trust at the death of the first to die, or have some trust for kids arise at that point. That issue is missed in a lot of conversations that I've witnessed on this topic.
Can you, just for sake of time, and I don't know if this is even possible, but in a minute or so, can you tell us the differences between our esteemed presidential candidates, should they remain healthy and continue to pursue office, in the event of a Trump presidency or a Clinton presidency?
Okay. I think it's no secret that the estate tax has been somewhat of a lightning rod for presidential candidates and parties for some time. I think, put rather simply, the Republican/conservative approach for decades has been that the estate tax should be abolished, and it should not exist, that these are typically assets that have been accumulated from earned income. You've already paid income tax on them. Why should the government take more when you die? The term death tax was coined in connection with the effort to abolish the estate tax. We actually had it abolished in the year 2010, but that was not a permanent abolishment, and so, as you saw from the earlier chart, it was reenacted in 2011 with the exemption of $5 million. So all that is to say that Trump has taken the conservative approach, and his position, as I understand it, is the estate tax should be abolished. I think that's a pretty safe position for a Republican candidate. Mrs. Clinton, predictably, follows the Democratic platform, which for years has been that the accumulation of wealth ultimately is not good in a democratic society, and one of the key ways that you redistribute wealth is that you take it from the rich when they die and distribute it amongst the various interests of the government. So her position, as I understand it, is the same as President Obama's, and that is that the exemption should be $3.5 million per person, so she would reduce the exemption amount. That's very important because going back to our earlier discussions, again, if she is successful and Democrats get enough seats in the House and Senate that they do tax reform, we would very possibly go back to a $3.5 million per person regimen, and a lot of people who thought they were outside of the scope of the estate tax are now drawn back in. And in that regard, when we looked at Exhibit A, I didn't mention this, but it bears note that the life insurance, a lot of people don't recognize that the proceeds or the death benefit of life insurance is part of what gets calculated in determining one's estate and in determining whether you hit the tax levels. And there are a lot of young people with very substantial term insurance coverages that get pushed into a federal state tax regimen very early and unexpectedly. So if we do go back to the $3.5 million under the President Obama's current platform and Mrs. Clinton's expected platform, there are going to be a lot of people that are having to deal with the state tax that didn't think they would be.
Well, and appreciate those of you out there that are submitting questions. One of them that we might have time for now, I don't know if this is an appropriate time to hit this one or not, Stan, but let's try if we can. How does all of this affect a client that's making annual estate planning gifts?
Yeah, that's a good question, because for many years, when you go back to an estate tax exemption of $1 million, which again, as you saw, wasn't that many years ago, clients that had several millions of dollars were being urged and pushed, make annual gifts to your children and grandchildren to reduce the size of your estate so that when you die, we're not paying a large federal state tax bill. So many people got into the habit of each year giving 10, or it was indexed to inflation, so it's currently $14,000 a year, to take advantage of that annual gifting right. So if an individual had 3 children and they were married and handful of grandkids, each year they would religiously write $10,000 or now $14,000 checks to each of those children and spouses of children and grandchildren and so on, as a way to make tax-free movement of resources to the lower generations, thereby decreasing the size of their estate and the estate tax that's payable. What I have found is people continue to do that, even those that don't have particularly large estates, because that's what they were doing. And when you meet with them and you say, your total estate, married couple, is $3 million, your combined exemption right now is just shy of $11 million, you don't have to continue making those gifts, and they look at you like, well, I wish somebody would have told me, because they were getting to the point where they started to worry about if they needed nursing care and all of that. So people who are on autopilot gifting ought to rethink, is the gifting accomplishing the tax purpose? And where it really becomes troubling is if they are gifting securities as opposed to cash. Those gifted securities will never get the benefit of the stepped-up basis at death, and so it's almost a negative to have gifted those during lifetime. And I still see some clients that have large concentrated stock positions, and they're gifting out these shares with basically no basis to their kids and grandkids, when it's not saving any estate tax because of these big exclusions, and the kids are getting mom and dad's basis, which is very, very low, and so it actually ends up being a negative from an estate tax and income tax planning standpoint.
Well, there's another question that's come in, but before we get to it, do you want to touch on ILETs?
Absolutely. This is continues to be a little bit of a hot topic because ILETs are irrevocable life insurance trusts. And as I mentioned a bit ago, life insurance that a person owns is an asset that gets added into the pot in determining whether they have to pay federal estate tax. Life insurance often, not always, but often, especially term insurance, for example, is an asset that a person typically isn't looking to for retirement purposes and enhancing quality of life. It's often a death benefit. So because of that, for years, it was common to transfer the ownership of a life insurance policy into a trust so that when the insured died, that policy was not a part of his or her estate. The trust that would be used for that is known as an ILET or an irrevocable life insurance trust. You couldn't use a revocable trust because it was still then in the person's estate. There are a lot of these out there still, and a lot of clients will say, you know, what do we do with those now that we have the new Estate Tax Act? That requires careful analysis. You really have to look at the full picture. You have to look at what happens if we do go back to 3.5 million. What happens if their future investments and assets continue to appreciate. You have to look at the total picture and then make a determination of, does the policy fulfill a purpose? Do we even want to keep the insurance? Many times these policies were obtained to, quote, pay for estate tax. If there's no estate tax, does the trust still perform, or does the policy still perform a purpose? And so in that context, these are trusts that I have found in probably an appreciable percentage of the time just get terminated. Either the policy's let go, or you conclude the trust and you transfer the ownership of the policy out to some individual, or you do other things to address the fact that the trust is no longer needed. It is an area that requires some work and some analysis, but I continue to write irrevocable insurance trusts. If you have a high net worth individual who's buying a substantial insurance policy, it doesn't make sense for that person to own the policy, and so you do still create these. It's just not for the mom and pop that they were for 15 years ago.
Another question, and I think it might be a appropriate time to put this one in. I own a family. I'm part of a family-owned business, and I hear a lot of chatter in the press about changes to how those are going to be valued. Can you comment?
Yeah, this is. I would say the clock is ticking. Is the best way I can say it. On August 2nd, so just a little over a month ago, new Treasury regulation was promulgated. It's a proposed regulation, thankfully. It's not final. I believe it's the first week of December. There are going to be hearings on this, and it will be met with extreme resistance. There are cynical people, probably the speaker included, who view this as a last-ditch effort by the current administration to pass something that they couldn't get through Congress. And the long and short of it is this Treasury regulation would effectively, and I'm simplifying for purposes of time, but effectively makes the valuation of family businesses such that you no longer get the benefit of minority interest discounts and lack of control discounts. So if a family owns a controlling interest in a business, and Dad died and owned 30% of that business, you would value the business and you'd take 30% of that, and then you would apply discounts to come up with what is a true reflection of what somebody would buy for a minority non-controlling interest in a closely held business. I mean, it's common sense. It's been in the law for decades. The Republican Party, I think, understands the reality behind that. At least the liberal wing of the Democratic Party has been after this for years because it has been misused. It has been abused in certain contexts, and it's drawn the ire of the administration, and they could not get it passed through Congress, so they have implemented this Treasury regulation, which essentially and effectively would eliminate minority and lack of control discounts in family-owned businesses. And that's a simplification, but it's if you read anything about it, you'll know it's not an exaggeration.
Another question, again, along the same lines that's come in. Are there any comments that you would have on proposed changes to Pennsylvania estate taxes?
Yeah, Pennsylvania is one of the few states that has an inheritance tax, and we have what essentially is a marital deduction and then a reasonably negotiable rate for transfers to kids and grandkids of 4.5%. Aside from continuing tweaking with exemptions for family farms and things of that nature, that law seems to be pretty well established and an important part of our budget. And quite honestly, I just don't see the basic format of that changing anytime soon. I would say if you're dealing with individuals that are leaving substantial assets to people other than spouse and kids and grandkids, that tax can become very onerous. I'm working on an estate right now where it goes to nieces and nephews, and they are all taxed at the rate of 15% with no exemption amount. So that ends up being more onerous than what the federal state tax would be in certain instances.
Why don't we go ahead and advance to the slide with Stan's contact information. We have about 4 or 5 minutes left here, and there's some questions that have been queued up. I'll get to as many of these as we can, and then for those that we are not able to get to, feel free to reach out to us for some follow-up. But the next one is this: what's the future for family limited partnerships?
Yeah, I think that device, and I'll call it a device or technique, essentially was being abused. What would happen is a family would take an investment portfolio of marketable securities, put those into a family partnership, typically limited partnership, and give out limited partnership units to the kids and grandkids, and take substantial discounts for lack of control and lack of marketability. And so you're taking $1 million investment portfolio and saying a 1% interest in that is worth 70 cents on the dollar, for example. That's the kind of abusive use of discounting that has attracted this draconian Treasury regulation proposal. So clearly, the Treasury Department doesn't want those, will attack those. Now, are there legitimate uses? Absolutely. When you look at a family that owns a commercial rental property, a business entity, a true and proper use of a business entity with resultant discounts ought to work, but a lot's going to depend on what happens with this proposal in the Treasury regulation.
All right, another question here. Can you comment on what's being done with respect to charitable planning in wills and trusts?
That remains a viable part of an estate plan, and by that I'm referring typically to two and maybe 3 areas. Charitable remainder trusts continue to offer good opportunities in estate planning where you are providing both for family members and for charities, and the charitable deduction that is a part of that continues to offer interesting opportunities. There are still possible ways to couple that with the drawdown of retirement assets, and so charitable remainder trusts are still very effective and very much a part of the estate planning area. Related to that also would be the family foundation. We continue to see a good interest in family foundations, and the charitable deductions that they offer, particularly for higher net worth families, continue to be very viable in the estate planning field after the 2010 Tax Act.
I think we have time, Stan, for one more. Unique planning options, in your mind anyway, for available for retirement plans.
They continue, and by this we're referring to an individual's 401k or IRA account. They continue to offer challenges in how they get dealt with in the estate planning field. This could be a complete topic unto itself because there are so many nuances, but they still, Congress still allows for the stretch out of inherited IRAs, and so long as that's in the law, it requires careful handling of the beneficiaries of IRAs and 401ks, and they have to be fully integrated into the estate plan that is implemented post-2010.
Well, Stan, we'll pause right there for a second. I'm going to bounce it over to Tyler for a quick announcement, and then we'll be right back.
Thank you once again for joining us for this presentation produced by McConley & Asbury. We hope you join us for our upcoming events. You can stay up to date with news and learn more about our upcoming events by visiting us at www.macpas.com. Thanks again, and have a great day.